only to prejudice your lordships, that look, all these years there is no acquisition, the acquisition is valid, the acquisition could not have been given back, 48A is wrongly done, notification is wrong, everything is wrong. Document said otherwise. Now, this 50-50 rule. It is clear that the petitioner himself had no role to play, or even deliberations leading to the decisions in the case of denotification, registration of deeds, decision by Muda with regard to 50-50 rule being applied, and allotment of compensatory sites to wife of the petitioner. Otherwise, had I got a role to play, I would certainly not have taken at least a decade to get this done. And had I a role to play, some of the most operative decisions would not have been taken when I was in the opposition. Some of the major ones. In fact, the Muda decision was taken in 2020 and implemented in 21-22 at a time when the petitioner was in opposition and not even a part of the government. And this is given to 19 or 20 or whatever number of other people also. It's a general policy decision. But nothing to do with me.
But your son was a part of the board there in
I'll be showing that board. That's part of my list.
By being an MLA.
MLA. He's ex officio.
Ex officio member of the decision-making body on that particular day. Your son was a part of it.
Which is a ex officio requirement A. I did not make him B. The decision is across the board for so many people.
No, true. It's across the board. But
and I'll be dealing with that.
2 meetings.
And he is fortunately not named as
2
an accused.
meetings, one in 2020 and one in 2021.
Yes. And they have not made him an accused. They have not short sanctioned.
They are not.
No, it's just I'm just saying these 2 or 3 facts, but they're in the list of dates. Now, let us come to the next point. Shamsher Singh is important. Don't brush it aside as the respondents have done. They've completely brushed aside. This remains the bedrock for the last 60 years. 7 judges. Bedrock on constitutional law. President, governor, both. There's a typo there. 1974, not IG 74. Typo there.
Yes, sir.
The president as well as the governor is the constitutional or formal head. The president as well as the governor exercises his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function in his discretion. Wherever the constitution requires the satisfaction of the president or the governor for the exercise by the president or the governor of any power or function, the satisfaction required by the constitution is not the personal satisfaction of the president or governor, but the satisfaction of the president or governor in the constitutional sense in the cabinet system of government. That is, satisfaction of his council of ministers on whose aid and advice the president or the governor generally exercises all his powers and duties. And the old saying, the elected people have a fundamental right, a duty, I would say, to do good. But they also have a right, not a fundamental right, to do bad and wrong. But it is their right to do wrong. It is my right to do wrong, and this population will set me right. It is not the governor's right to set me right, or the president's, is what Shamsher Singh's soul and spirit is. That's the meaning of elected democracy, or in a parliamentary system. It may not be in a presidential system the same way. Then, 54. The provisions of the constitution expressly require the governor to exercise his powers are contained in articles to illustrate. Now, one article is given on the 3rd line. Come to the boldface. The other articles which speak of the discretion, there are typos here. Typos should have not been seen. Paras, what is that section? S2 and 18.3 of the 6th schedule. Then articles so and so. The discretion conferred on the governor means that at the constitutional head or formal head, the part. This is one of the Northeast. Those powers, your lordship has special powers there. Then 55.
Yes.
This is the failure of constitutional machinery. In the context, Article 163, I don't know why only the articles are wrongly typed. Everything else is correctly typed. The number is 163.
Article 163.
Somebody is going with the uppercase and the lowercase is this.
That's
problem.
Not correctly typed. That's all.
163 actually.
Yes.
Multiple, all of them are like
163.2 it should be.
In article, in this context, 163.2 is explicable on the decision of the governor in his discretion shall be final and the validity shall not be called in question. Next, 2 lines later, In all other matters where the governor acts in his discretion, he will act in harmony with his council of ministers. The constitution does not aim at providing a parallel administration in the state by allowing the governor to go against the advice of the council of ministers. In such matters where the governor is to exercise his discretion, I'm reading para 56, he must discharge his duties to the best of his judgment. The governor is required to pursue such courses which are not detrimental to the state. For the foregoing reasons, we hold that president or governor acts in the aid and advice of the council of ministers, with the prime minister at the head in the case of the union, chief minister at the head in the case of the state, in all matters which vest in the executive, whether those functions are executive or legislative in character. Neither the president nor governor is to exercise executive functions personally. I try and summarize some things in page 12. Next page. In relation, I put them point formulas. In relation to functions that are vested in the executive, the governor shall act at the aid and advice of the council with the chief minister at his head. The governor shall not exercise executive functions personally. 48 and 57 paras. Where the constitution provides that the governor shall act in his discretion, here the articles are correctly put, Malas. Even in these matters, the governor shall act in harmony with his council of ministers. These are Malas nuances which we tend to forget. It is not, Malas, very interesting nuance. This Shamsher Singh, 74, Malas, is saying that even where he has a separate power, he must act in harmony with me in that. Look at the whole delicate balance. You can't say automatically I receive the cabinet decision because the chief minister is involved, I'll differ. Thus, there is a constitutional restriction on the discretion which is not to be exercised as a personal function or as a function conferred on him eo nomine. In very limited scenarios, such as under 356 is a classic case, fellows, and 200, the governor may act in his own discretion even against the advice of his council. In such cases, the governor is to exercise his duty to the best of his judgment. That's para 55 and 56. Now, the most important, Justice Krishnaiyer. Now, why it is misrepresented, Justice Krishnaiyer is right. Not a word in the majority. He's concurring. Not a word in the majority dilutes or overrules or goes against him. Then why should Lordship not read Krishnaiyer? Justice Krishnaiyer just brush aside, he's a concurrence. But concurrence is not a dissent, Malas. Please don't read the concurrence as a dissent. You can point out that this concurrence is violated by this part of the majority. That I can understand. Not a word. Ignore it because of the concurrence. And Justice Krishnaiyer spoke for himself, Justice Bhagwati. If the inner voice of the founding fathers may be any guide, para 113, it is proved beyond reasonable doubt that the president and for sure the governor enjoys nothing more and nothing less than the status of a constitutional head in a cabinet type government, a few exceptions and marginal reservations apart. Mark this word, a few exceptions and marginal reservations apart.
Yes.
Actually, the governor has more powers than the president.
Yes.
People tend to forget that. President is even more limited. Governor has little extra powers. For example, president has no 356 for us. Yes. Our Pakistan president has a 356, which he has liberally excised 2 or 3 times. He dismisses the national government with us. We decided against having that in the president. We had it only for the governor. Nobody can dismiss the central government here with us. Of course, there is some qualitative difference between the position of the president and governor. The former, under 74, has no discretionary powers. The latter too has none, save in tiny strips. Look at the approach. Tiny strips covered by, please forgive me for the typos, but it's 163, somehow coming at 1C3. And all the others are given. These discretionary powers exist only where expressly spelled out, and even these are not left to the sweet will of the governor, but are remote controlled by the union ministry. This is very important. Well, the governor, when he acts independently, so-called, is independent of the state government. But the union government is answerable to parliament with a whole set of provisions. Lordship knows the 356 proclamation expires if parliament doesn't approve it within a certain time period. Again, a minimal area centering around reports to be dispatched may not, that's for 356, not 35C, may not in the nature be amenable to ministerial advice. Now come to page 14. Even where express conferment of power of functions is written into the article, such business has to be disposed of decisively by the ministry, answerable to the legislature, and through it vicariously to the people, thus vindicating our democracy instead of surrendering it to a single summit soul. These are the simplest language which Justice Krishnaiyer may have used. He's one who's erring on the side of oversimplicity. But a single summit soul has a rhythmic alliteration, Manas, which exactly describes the reason to avoid the governor or the president. That single summit soul is the governor or the president, whose deification is incompatible with the basics of our political architecture. Lest national elections become but Dead Sea fruits, legislative organs become labels full of sound and fury, signifying nothing. And the Council of Ministers put in a quandary responsibility to the House of the People and submission to the personal decision of the head of state. A parliamentary style republic like ours could not have conceptualized its self-liquidation by this process. On the contrary, democratic, etc. Well, sometimes I think that how times have changed. Well, it's today, even if you have a person like Krishna Iyer, he could never go onto the bench. Because we are into narrow confines. You can't be in public life, you can't be in law, you can't be on the bench.
No, he was in public life.
Actively, a
Became-
minister.
Yes,
Forget active life.
as a
He was
minister.
Malas,
For 3 years.
and then became a judge.
Then became a judge of the Kerala.
Which is why he never made it to the top, Malas, but he was a senior judge. But Malas, nobody could raise a finger. That is the spirit of the times. Nobody could even suggest this. And one of my most cherished memories is that as a young student, I wrote an article in the Illustrated Weekly.
Oh, the then Illustrated
Weekly,
yes.
a very famous magazine
Yes,
about
yes.
election law. I had been in some elections seeing something. Election law, elections, law and reality. So I was juxtaposing. So, but Justice Krishna had retired by then in the 80s.
Yes.
Wrote a very nice note handwritten to me, saying, I read the article. He knew my father was, so he took the trouble of writing a note to me personally. And he read the whole thing and he wrote something which overwhelming to have him. Then 152. Long arguments on the terminological niceties of the various provisions, divorced from the essentials of parliamentary perspective, will land us in Himalayan constitutional blunders. Similarly, expressions like is satisfied, opinion, as he thinks fit, if it appears to, have to be interpreted by superimposing the invisible but very real presence of the ministry over the head of state. Opinion of, in the view of, appears to be. We declare the law of this round. This is 154, which was brushed aside by saying this is only a concurrence. So I've quoted it. Please tell me which part of the majority dilutes or violates 154, or tell the Lordship it is the overbreadth. Unless you do that, you can't just brush it aside. Supreme Court, 7 judges. In that way, Bomai could be, Bomai Lordship had 9 judges with 4 or 5 judgments. Most for all concurrences.
Yes, concurring.
Your Lordship doesn't brush aside just like that. Very Karnataka flavor, Bomai. The most important change in 356 has been that Mr. Hegde, by the time Bomai was delivered, he was the petitioner originally.
Yes, yes.
By the time Bomai was delivered, the government had changed 2-3 times.
Yes.
He never got the fruits of his victory. Subsequent to 2000, there are only 7, 8, 10 Maras 356s. Because your Lordship's judicial review was not only the same as Bomai, very swift. Very swift.
So many things.
No, your Lordship's judicial review was very swift. I've had the privilege of assisting the court in Uttarakhand, Karnataka,
yes.
Maharashtra. Your Lordship decided within a few weeks, this way or that way. So 356 did not become a very valuable tool to dismiss governments because your Lordship said reinstall him back. In all these cases, Uttarakhand, Kannada, have the elections or have a floor test and all that. Bomai took 3-4 years before the man lost several governments. So he got a Parik victory.
Yes, it was a Parik victory.
It was a Parik victory, although he established law forever. We declare the law of this branch of our constitution to be that the president and governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon in accordance with the advice of their ministers, save in a few well-known exceptional situations. Without being dogmatic or exhaustive. This was read to your Lordship, so I'm reading it, Wallace. Please see the totality. Is it a fair interpretation? To say that this means non-exhaustive, means each case by case your Lordship will keep adding to the governor's powers. That's not fair, Wallace. It's against the constitutional scheme. without being dogmatic or exhaustive, these situations relate to the choice of the Prime Minister, restricted through this choice by the paramount consideration it should come. But this word exhaustive here means something totally different. They are saying we are obviously not itemizing everything. It is not a license or an invitation for my lords to keep on having adventurous additions, which is what they are suggesting. The dismissal of a government which has lost its majority in the House but refuses to quit. The dissolution of the House for an appeal to the country is necessitous. Although this area, the head of state should avoid getting involved in politics, must be advised by the Prime Minister, who will eventually take the responsibility. We do not examine in detail the constitutional proprieties in these predicaments except to utter the caution that even here the action must be compelled by the peril to democracy, and the appeal to the House or to the country must become blatantly obligatory. Now, my conclusion, Malas, on this part. As such, the declaration of law in 154, which forms part of a concurring judgment, must be seen in proper context. By no stretch of imagination can the judgment in Shamsher be seen as providing an open-ended, non-executive list of subjects. That's the crucial point, where the Honorable Governor may exercise, etc. But rather the court expressly said it is confined to a few well-known exceptional situations, which your lordship may in a very calibrated, controlled manner, restrained manner, sometimes allow. Then, Malas, the last judgment is where happened recently, Malas, the Maharashtra thing. This is not about this or 10th schedule, but Malas, just 2 minutes. Very after.
Continue at 2:30.
I'll continue.
Yes.
2:30, Malas?
2:30. Yes.